You want to explain a little bit about what the real estate commission is looking at when they put out these advisories and how that all works in that process?
Yeah, so the commission would want me to make sure that they are calling them memos, not advisories,
Memos, okay.
because nothing has precedential value at the commission. But I always kind of call them more spoiler. They're telling you what's bothering them. They're telling you what they're getting calls on. They're telling you what they're getting complaints about. If something they get one call every 10 years about, they're not going to go through the effort of doing a memo on it. So the things that they're doing memos are here are the things we're getting a lot of questions about, either directly to the commission or the commissioners themselves are getting those phone calls. And so they're kind of laying out, hey, here's what's really uh, you know, bugging us. I mean, I used to get asked before they only started doing these maybe two years ago, would be, hey, what are the hot button issues? What's really on top of mind for the commission? And before I had to kind of think about it just based off the meetings. Now they're kind of telling you what is top of mind for them.
All right. And so with that, they're also starting up their inspections again. You want to talk a little bit about the inspections and what they're looking for and what brokers need and what agents are going to be, their brokers are going to be making sure they have ready for these inspections.
Yeah, so the commission has always had the ability to do inspections, but quite frankly, they just haven't been doing them with any frequency until lately. They have revamped that effort and are going to be the stated goal is to go to every brokerage firm in the state of South Carolina in the next 3 years. Um, and so what they have done in consultation with the task force that I served on was create sort of a checklist for inspectors when they go into offices for what to find. But they have actually made that checklist available for you to see. One of the most common questions I get is where can I find that checklist? So I'm going to share my screen and show you exactly where you can get it. So you would go down to go to the Real Estate Commission website, approved resources, inspections information. There's a video about how to be prepared, and then they actually have the sample form. So this form here is the exact same form the Real Estate Commission inspector is going to use when they evaluate your office. So again, as I've been saying, they've given you the answer key to the test. They have told you immediately what they're looking for. So before I closed out a file, I would just go through and make sure my file has all the necessary information that they're looking for. Make sure that it has every agency agreement that it needs. All those agent agreements are dated, they're signed. Every contract is in there, it's dated, it's signed. If there was escrow money that was being held, and it was being held by your brokerage, you have an accounting for what happened with that. If it was being held at a different brokerage or at a law firm, you have a notation in your file. Hey, the escrow funds in this case were not held there because what they're going to essentially do is they're going to go to your office and they're going to say, hey, give us randomly a file from February 2023, give us one from July 2024, give us one from March 2025. And they're going to say, we want one that you did dual agency. We want one that you did this. And they're going to pull kind of at random. And so it doesn't matter if you do it right 95% of the time, because if they pull one of the files that you didn't do it correctly, it doesn't matter that the rest of them were in compliance. So I would be mindful of that. To look at this, I mean, mostly it's the record retention. They're not going to ask for anything more than 5 years. They're going to want to
That's what
have,
I was about to say. 5 years back, make sure your files are there.
correct. It's 5 years, and it's actually stated in statute what has to be in the file for 5 years. The other question we've been getting is, well, I don't have physical files. It is fine that you have them in the cloud. If they ask for them, you just simply have to print them. Um, so you do not have to have physical copies, but you ever have copies in the cloud, and you need to make sure that you have some sort of backup. You don't want to have it just one place, and then something goes awry and you lose all of your files.
All right, and how quick do you have to be able to go grab them out of the cloud? Like, should you have them? Make sure, obviously, best practice, make sure you have them organized in the cloud. But if you got to go in, if they're not, you got to go into the transaction management system, download the forms and all that were signed.
Yeah, I think they're going to be reasonable about it. I would say that if you are just continue delaying for delay's sake, that's going to make you look guilty. And that, you can't simply just run the clock out on these. That's been a common misconception in the past is, hey, if I ignore the investigator or ignore the inspector, that they'll just go away. You're actually going to probably just redouble their efforts if you do that. But you can kind of look here. There's the big 7 things that you gotta have. So I would just make sure that you have those, be prepared for any of those. The advantage is if you're in state, you just have to be ready for files. If you're out of state and they do the inspection, you actually have to send them a spreadsheet of every file that you've done for the last 5 years. And then they send back to you which ones they want.
What is considered out of state?
Your office is located out of state.
Okay.
Because
And
the inspector can't cross state lines to go investigate you. So that's why
and
they have
the
you have to,
written go ahead. Sorry.
and that's why if you're out of state, you have to send them everything because they can't go into your office.
And the written office policy, SCR has one for them, right? For the brokers, right?
Yes. Let's see if I can pull that up real quick. If I can't log in, I'll show you where it is. All right. So if you go to screaltors.org, go down to legal hotline. If you click there, once you get through the firewall, it will do this real quick. All right. So once you're through here, legal resources, office policies. There are 2 versions we have on our website. We have a long version, which is a Word document that you can fill in. You have a short version, which is a PDF, which is 2 pages, includes everything that's needed for to be in compliance with license law. If you get an office inspection, just print this short version, check the check boxes, and move on. That you do not need to provide the real estate commission to your longer office policy that talks about your dispute resolution and your commission splits and all that other stuff. They simply need to know the very basics of, what kind of agency do we provide? Do we do, fair housing, that type stuff. So just print the short version if the real estate commission shows up.
Awesome. All right. And then so let's get into some of these memos. I think the first one we're going to talk about today is the advertising memo.
Yeah, absolutely. And so let me make sure that y'all know where all these memos are. So go to the the most recent ones will pop up under this alert thing here, but there are some that are archived. So what you're going to do is go to the Real Estate Commission website, lr.sc.gov/RE, go down to commission information, publication and news, and then all the alerts are right there. So the first one Ryan mentioned is advertising. So I can tell you that is probably the number one thing commissioners get calls about. It's one of the top things we get calls at the real estate commission about. And those of you who are brokers in charge, it's probably one of the top things you get questions about. And all this is really coming. The biggest thing they have, or the question they get again, is how do you advertise somebody's listing that is not your brokerage's listing? And again, it really comes down to the only way to do that is you have to have written permission from the listing broker to do it. And you need to give the listing broker you need to give the listing brokerage credit at your proper attribution in the listing in your advertisement. And
I think that the key there, Austin, is the brokerage permission.
Correct.
The broker's permission, not an agent's permission.
Correct. And the agent or the agent, the brokerage has to get permission from the seller. So the seller gives permission to the broker to say, sure, let another broker share my pictures of my house online, and then you can do it. So a couple of the interesting things that they have really highlighted, and again, I'm simply the messenger here, are things where
If you have a problem with it, take it up with the real estate commission, not Austin.
thank you. All right. So I was trying to find one of the examples they gave here is if you do a um you send out an email on a monthly basis that just goes, here's all the properties that sold in an area, or more specifically, you do the postcard of, hey, just sold in a particular neighborhood. The problem is you weren't involved in the transaction. Even though that is public information that the property sold, you are advertising a home that was not one that you were involved in. So you need to get proper permission to do that. You need to, if nothing else, if under the under license law, you've also got an issue on the code of ethics for not painting a true picture in your advertising. If I get a postcard from Ryan that says, "Hey, just sold," with a picture of a house on it, and I'm going, "What are you talking?" And Ryan wasn't involved at all. Well, the only name I see on it is Ryan's. So I see 123 Main Street was sold, and I see Ryan's name on it. Well, the reasonable consumer is going to go, well, obviously Ryan had something to do with that sale, when Ryan actually maybe didn't have anything to do with that sale. When you get even worse on this, if you send that out to a neighborhood, hey, 123 Main Street just sold in this neighborhood, and Ryan goes, well, I want to drum up business in this neighborhood, so I'm going to send out a postcard letting everybody know 123 Main Street sold, even though it was sold by two different brokerages. Well, there's a guarantee that Ryan's postcard's either going to the buyer of the property or the seller of the property, both of whom are going to know that Ryan had nothing to do with it. And so the first thing they're going to do when they get the postcard is send to their broker and go, hey, who's Ryan and why is he claiming that he was involved in the sale of our house? The agent who finds that out is not going to be happy, and that's where complaints get filed. Whereas if you would send down instead, hey, just want to let y'all know this property was sold in this neighborhood. It was sold by this broker and this broker. But if you would like to, I'm happy to work with you. I know no one's probably doing that, but to be in compliance with the law, that's what you would need to do. Gets into the fact that broker, so ultimately, everything we talked about is broker. It's just because the agent did it. It wasn't me as the broker in charge. You as a broker in charge are ultimately responsible for every single piece of advertisement that goes out from your brokerage. Um, so either need to be as a broker in charge physically reviewing every single one of these, or you need to have very clear policies in place for some sort of check. But knowing, hey, if somebody goes wrong with it, I'm ultimately going to be the one who bears. I'm going to be ultimately responsible because it, happened under my umbrella.
All right, awesome. We got a couple questions on this I want to run through a little bit, okay?
Hmm.
One question came about, does this apply to non-residential property like commercial property and land and stuff like that?
Yes, there's no distinction in statute on what type of property.
All right. Um, so some just show, so a lot of people say postcards or a grid of stats, things like that about recently sold where you're not at, where they're identified by address but not pictures.
Yeah, I guess that the counter to that would be if you send out to the general public who buys a house every 7, 8, 10, 15 years, a list of properties that were sold, and the only real estate brokerage name or the only agent's name they see on the entire advertisement is yours, it stands to reason that at least one person who receives that is going to think, oh, look at all the sales this one person did. So, to me, if you're going to put out, even though it is public information,
Would
I
you
would
say
have
that not
some
all
sort.
these, I mean, would it work to say not all these sales were represented by this brokerage
The safest way would be to put who actually did the sale.
of each one?
Yes,
All right. And how are CMAs handled? I mean, I assume that's not advertising, or
that's
is
not
that?
advertising because that's client service.
Okay.
Yeah, it's when you're putting essentially when you are. And the biggest thing with the commission with all this advertising is if you are trying to drum up business for yourself or clicks or eyeballs for your business on the behalf of somebody else's work without giving them proper attribution.
And this is not um share, what about through how does this work with the rules of IDX of MLS? And you're having permission within MLS for sharing listings.
feel like they did do something with IDX.
They have that in there. I know that. I saw that. Or maybe just MLS.
Is this the different one?
It was in the advertising memo, not the coming soon.
Okay, I didn't think it would be in the coming soon.
Try MLS.
Why is this? Okay, I think there may be a table.
But there was in there. I mean, as far as the exact MLS rules, you need to talk to CHS MLS, or whatever MLS you're asking about rules are for. But as far as display on a
There we go. Sorry, I
website,
was
there you
using the
go.
wrong. I was looking at the wrong advertising memo.
Oh,
There's an
sorry.
advertising memo, and there's a reminder of one. So this is the one, and this one actually gives me where I was trying to find earlier. Just the same case you thought I was just making it up. Is even if no imagery is used, simply referencing a property address in any form, including social media captions, blogs, newsletter, print advertising, postcards, buyer success reels, or market updates, is advertising. That is directly from the Real Estate Commission. And then if you go back to statute, it says you cannot advertise property without those things of written permission from the listing broker and proper attribution. So if they're considering just simply naming the addresses in a market report as advertising, then that means it falls under the advertising rules. So where it gets into the MLS, you know, creating marketing materials derived from the MLS data could give the appearance that the brokerage represents identified listings of another brokerage without retaining. This would be a violation that's distinguished from the use of an IDX feed on the brokerage website. So an IDX feed, fine. When you create marketing materials, I think that's where they're making a distinction. But you could take it from right there that if they're saying this is distinguished from an IDX feed on your brokerage website, that the IDX feed is not an issue. It's creating marketing materials.
And reminder, whether the agent is a realtor or non-realtor, this all applies because this South Carolina real estate licensing law. So
Correct.
as long as they're licensed in South Carolina, this is all the same for all licensees. Um, the other question I had come through here to look at is what a broker another agent's listing inside your own brokerage.
If it's within your same brokerage, then you're all the same. Yeah. If it's a brokerage listing, then it's as much the other agent's listing as it is your listing. You just need to make sure that you check with your client to make sure that they're okay with it because it's still ultimately their house. But inside a brokerage, same broker in charge, that is permissible as long as the seller is okay with it.
Does it have to have the brokerage when you're giving credit, just the brokerage name, or does it have to have the agent's name too?
Just the brokerage because the brokerage is the one who has the listing, not the agent.
All right. And when you're talking stats, if cumulative stats like 6 homes sold in Somerville or Goose Creek or something like that in this week, that's not it, right? It's just if you're actually putting a number of on the on the if you're actually putting addresses out, right? You need to source where the data is coming from, though, right?
Correct. I think it's a lot harder if you're saying, numbers now. I mean, you could still, I would say if you're still saying, hey, 6 houses were sold in Somerville and you weren't involved in any of them, somebody could still make the claim that you weren't being honest in advertising, but that's a different issue than
But if you're putting that, this is according to data from
right.
CHS like that,
Yeah,
that's
I think
clearly
you're a
showing where
lot
the data is
safer
coming
that
from.
way. I think you're a lot safer that way. It's, you know, it's really if you can say that you're misrepresenting, but if you're going, hey, here's just the available MLS data, I'm not spotlighting any particular property, I'm just giving you the raw data. I think that's a lot safer. Once you start putting addresses out there, even if you don't use any imagery, even if you don't put their picture, that's still the issue.
All right. The last question I have on here, I think is going to play into the next one. So I'm going to ask it because you'll probably want to get into the next memo as well with this is how does it apply to new construction homes when advertising an open house with their sales rep?
Yeah. So, well, two things with the builder. One is you see this one here using property information for self promotion without, I guess, um, without authorization. That is, if you have a broker, if you have a builder who says, "Hey, there's a new development in the area, why don't you come over, take some video, drum up some business," and you don't have the listing agreement, you shouldn't do it. And if they don't have a listing, if there is no listing broker, then you can't do it. Um, Really, it gets to builders are the same, builders agents are the same as any other is same as any other agent. If you're going to advertise their property, you got to have written permission from them to do it. So if you're going to live stream in the house, you got to have written permission from the listing broker. If you're going to put share a social media post, you need written permission from the listing broker. The fact that it's a builder on-site builder agent or it's by a builder brokerage does not make any difference. The difference would be if the builder is the owner themselves that has not got a listing brokerage, then that's like a FISBO, and you can't do any advertising for unrepresented property at all without a listing agreement.
All right. And then, so with that wrapped up, you want to move into the builder memo?
Yeah. All right. So this one I'm going to try and make a little simpler. So this one was put out because there is an exemption in North Carolina and Georgia that allows a builder employee to essentially work on behalf of the builder to sell property, and they don't necessarily have to be a licensed real estate licensee. We do not have that exemption in South Carolina. So what all this is saying is for you to sell a house on behalf of the builder, you need to be licensed. And with that means you have to abide by all the same rules for licensure that everybody else does.
So
Um,
that includes like all the stuff that in your office in your business that you'd have to have a licensee be able to answer. The builder
yeah,
has to have a licensee be able to answer, not a marketing director, not a marketing coordinator, or something like that.
yeah, absolutely. And same thing. If somebody was to come into your office, the first thing you would have to do is talk to them and say, "Hey, are you working with somebody? Here's a disclosure of brokerage relationship form." Exact same thing for a builder. If somebody came into your office and said, "Hey, I'm currently working with Ryan," you wouldn't just keep working with him and be like, "Hey, you're working with Ryan. I gotta step back." So that's all this memo is really saying is there a licensee who happens to work for a builder is no different than a licensee who doesn't work for a builder. You're
So
all
this
real estate
whole idea
licensees.
that you have to sign your client in and all that before you interfere with agency relations doesn't really exist in South Carolina.
Yeah, yeah. I mean that it's certainly
Because
so.
if you already have a buyer agency agreement with them or a written agreement with a buyer, and even if they go into a model home, they still have an agency relationship with you if your written agreement with the buyer covers that.
Correct. So I'll kind of take that two ways. So if you have agency with a buy with a buyer, the fact that that buyer had previously gone and looked at a house at the new construction place does not, and they didn't sign any agency, they just simply showed up at that open house or the model home. That does not invalidate your agency agreement. Your agency agreement still holds. Now, if the builder says, "Hey, because we essentially saw them first, we don't think we should have to pay you any cooperating compensation," that is completely legal 8 days a week.
Well, I meant after, yeah, the compensation piece is
Yeah.
completely different, right? I'm talking
And
about interfere with the
that's the
agency
distinction we
relationship.
get on the hotline is, hey, they still got to work with you. But again, going to Article 3 of the Code of Ethics, cooperation and compensation are not the same thing. Now, one of the other issues we see, and I think there's notice of this in this memo, is where an on-site agent says, "Hey, we just prefer to deal directly with the buyer. We appreciate that we understand that you guys have agency, but we don't want to deal with your buyers. We don't want to deal with the buyer's agent." That is not actually acting in the best interest of the seller. That's not cooperating. That is in violation of license law. So again, if you have agency with a buyer, the listing side has to respect that. They can't interfere with it. They got to work with you, but that does not mean they have to pay you.
Right. And that's the same. I want to be very clear, Austin. In today's rules, that's the same as any
Correct.
transaction,
Correct.
right? Like
Yeah.
the idea that procuring cause has changed because there is no payment offered out in unilateral offer compensation and acceptance of it in MLS rules like there used to be. And so the idea that being paid on that transaction is the same as anything.
Correct. Yeah.
I mean, what?
Essentially they wrote a 4-page memo to say builders agents are real estate licensees just like everybody else.
Yes. And that also applies to, and I've heard this by some real estate commissioners, also as a buyer agent working with a buyer, you have a higher duty than just dropping them off at essentially sending them over to a new home community as well.
Correct. Yeah. If you say, hey, because hey, the names are booked, then I'm not helping anymore. Just like you got to act in the best interest of the client, just like the on-site agent does. So if the on-site agent has to cooperate with you, communicate with you, you've got to represent and advocate for your buyer in the same way. So neither of you get to essentially wash your hands of the buyer in this transaction or your seller.
Right. All right. Let me get to some of the questions on this stuff. Um, so a lot of people are still talking about advertising in builders, though, taking video of new construction, neighborhood, and floor plan, but not specifying address and home.
If you don't have the list, if it's completely unlisted property, it can't be done at all. If it has a listing brokerage, then you're going to need to get written permission from that listing broker in order to do it and give them proper attribution.
And on that note, I want to build up is like advertising listings that you don't have a listing agreement for, or there is no listing agreement for, is against South Carolina real estate license law, right?
Correct. Yeah,
Right. So
4057,
we hear a
135
ton of
U.
that, right? Well, I don't have to put in the MLS. I don't have to deal with clear cooperation policy because there's no listing agreement for this property. That is a violation of South Carolina real estate license law to advertise a property without a listing agreement.
Correct. There's only three ways. I always say there's only three ways you can advertise property in the state of South Carolina. First one is you own it. Second one is you have a listing agreement with the person who does own it. Third is you have a written agreement from the listing brokerage who does have the listing and you give them proper attribution. So if you can't go into one of those three buckets, you can't advertise the property.
And that, I mean, that's what even agents that say, well, that's off market. Well, yeah, that's off market. You still need one of those three to be able to advertise it.
1,000%.
All right.
And again, I always tell people the commission gets 1,000 complaints a year. So the easiest ones kind of go to the front of the line. Advertising a property without a written agreement, that one's super easy. Hey, I saw an advertisement from Ryan for 123 Main Street. We knock on Ryan's door. Ryan, we saw your advertisement for 123 Main Street. Can you show us where you own 123 Main Street? Yeah, it's not my house. Okay, great. Can you show us the listing agreement for 123 Main Street? Don't have one. All right, can you show us some written email or something from the listing brokerage did? Yeah, I didn't talk to anybody. That's the entire investigation. It's not any more difficult than that.
All right. And so let me ask you this because this is one we get a lot. Is someone that is advertising a property, they claim it off market, but then they don't have a listing agreement. How does another agent go and complain to the real estate commission about that?
Real Estate Commission website, file a complaint, click the link. So that's as simple as it is. It's Real Estate Commission website, file a complaint, hit the complaint link, file the complaint. 2 clicks of a button to get to the complaint form.
All right. I mean, now we're getting a little specific on questions, but what if a buyer goes to a model home without me knowing, signs in with their name, number, email, leaves me to call their buyer's agent, signs a buyer agency agreement with me, then wants to go back and buy a home with the builder? You represent that buyer, but as with any listing, same with an open house, a client goes to an open house, doesn't tell them they're with you, comes to you to write the offer. That other agent has to cooperate with you, but does not have to compensate you.
Correct. Your buyer will have the buyer has in their comp in the buyer agency agreement an obligation to pay. So if the buyer does that, you're still going to get paid. It's just going to be from the buyer if there's no one else to assist.
Yes, as long as you force that. But yeah, I mean that's so essentially sending them to a buyer going to a open house even before you is the same difference as them going to an open house of a resale property before you and then coming to you and sign a buyer agency agreement includes that house. The way you structure it includes that house. You represent them on that deal. The other agent has to cooperate with you no matter what, but not compensate you.
Correct. And I think Ryan's made it laid out best is that the whole point of that memo was there's been kind of a unspoken belief or understanding that, hey, there's a different set of rules if it's new construction. New construction is a different type of real estate. The commission is essentially saying whether the house has been there 100 years or it's brand new, the rules are the same. There is no special set of rules for new construction.
All right, let's get into wholesaling, everyone's favorite topic as well.
All right, so we're gonna go back to commission resources. All right. So wholesaling. The biggest first question we get a lot is wholesaling versus assigning. All right, so here's what wholesaling is. Wholesaling is when you have a contractual interest. So you don't own the property, you just have a right to buy the house. But you market as if you actually have the property prior to taking ownership. So I'm under contract to buy 123 Main Street on October 1st, but I start marketing the property today. I try to sell 123 Main Street today when I don't actually own it. A signing would be, hey, I'm under contract to buy a house October 1st. I've got too many deals I'm working. Ryan, would you be willing to buy my position in this contract for $5,000? That is an assignment. That is allowed. But the biggest issue that comes with an assignment is you're allowed to sign under license law so long as you do not suggest, purport, or imply that you are selling the underlying property. Let me tell you how low of a bar that is. If somebody wants to get upset and file a complaint with me for wholesaling, they got to go find one person on earth who they could put on a witness stand and say, I thought Austin was selling the house, not the contract. That's it. That's the bar. If anybody, well, I saw Austin put a picture of the house out there. So if he put a picture of the house, I assumed he had the house to sell. Well, he put the property address. So I assume if he's talking about a property, he has a property to sell. I mean, the bar is really low. And that's really what it is one member of the public has to believe that you were selling the underlying property when what you don't have a property sale, you have a contractual position to sell.
All right. And then any question I see one question coming up. Let me see what this is. All right.
By the way, in paragraph 9 or page 4, these 9 things, the commission has laid out what I just kind of said that you can't suggest, purport, or imply that you're selling the underlying property. Here are some things they think would be suggesting, purporting, or implying you're selling the underlying property. A picture of the house, a survey, any description of the house, including number of rooms, bedrooms, bathrooms, square footage, year it was built, condition of the property, address, rental income history, neighborhood, or any details. So really all you can do is say, hey, I've got 5 deals I'm working on. I've got one that's closing August 1st or October 1st for $40,000. Ryan, would you like to buy my position in the contract for $5,000? Where's the house? I can't really advertise that.
All right.
Picture of the house? No, I can't really advertise that. I can give you the contract and then you can do your own bit
Seeing
work.
no questions on wholesaling, Austin, let's move on to manufactured housing.
Yeah, so I'm gonna spend a ton of time on this one, but I did want to let you know this is a fantastic our memo they put out. It has really this last page. So it has a decision tree, which really, if for those of you who call the Real Legal Hotline, this probably will answer about half to 90% of your questions. Um, and one of the benefits of this memo is the advice counsel for the Real Estate Commission currently, previously was the attorney for the Department of Motor Vehicles, which does a lot of the titling issues with manufactured housing. So she had that knowledge base coming into this. So a lot of this has been written with, hey, here's some issues that you may run into at the DMV. I would say of the memos we sent out to folks, this one probably has some of the highest approval ratings. So if you do manufacture housing, I would certainly review this memo because it will probably answer a number of your
Can you
questions.
walk through that decision tree for everyone?
Yeah. So, I mean, the first question, I mean, a lot of this is, hey, do I need a license? Because that's one of the biggest things of, hey, can I sell the home? So the first one is, hey, is it retired to the real estate? Meaning, are you selling? Is it on dirt? Um, Yes. So if it is, then we don't need a real estate license because it's not a manufactured home. Second is it being sold with the land? Yes, then we don't need a license. If no, then we're going to keep proceeding. Is it being sold in conjunction with a lease agreement for land? Then yes, then we don't need it. Number four, then we get into
And
is the
this is whether you need a manufactured home retail dealer license,
correct.
not a real estate license.
Correct. In addition to, yes.
Yeah,
So,
okay.
which is a lot of the questions, but it gets into, you know, hey, what do we do with the property that's being titled by the DMV and it's being sold with land? What do we do if it's being leased with land? I mean, so it's a pretty thorough memo. And then it talks about if it's actually on if it's permanently affixed to land, then it's no longer a manufactured home. It's because it's not moving.
All right. And then so for the next moving on the next one, because I don't see maybe a question in here. Give me a second. Um okay. And then we're moving on to scams. I think you wanted to go to next.
Correct. So this one, let's see. All right, so it's called Fraud Awareness Prevention Techniques. This is probably the best one they've ever put out. We've been getting a lot of calls, I'm sure y'all have, about folks using especially vacant land and scams and that type of stuff. So this is really kind of pointing out, hey, here's some things that you may be looking for. And then if it pops up, it's like this one, the buyer and seller states they are traveling, claims they can't meet in person, but can do everything by email. So what do you do? And you click the link here, and it will actually take you down to examples of what you should ask from them. One of the best things they did in here is it shows you how to verify for like a driver's license, what is legitimate, what's not. And apparently, there is a website you can go to that you can actually put in a number from a driver's license, and it will essentially tell you legitimate, fake, whatever it may be. Again, this was done by the board counsel who previously worked at DMV, so she was able to work with the DMV to get a lot of data and information for y'all that probably the average consumer has not had before. So a lot of, hey, here's what to do. So I kind of look at these 5 examples, and then you can go through and hey, what are some checks I can do? How can I go verify that this person's legitimate? A lot of uh, broad prevention techniques in there. And so if you have not already looked at this one, and I will put this one in the chat, I certainly would give this one a review.
All right. And then before we get into showing agents, I think we want to touch on the AI one as well.
Yeah. So AI, this one is there's really 2 parts to it. The first is saying, hey, under license law, you are ultimately responsible for everything that happens under your name. That means as a licensee, you're responsible for what is done in your name, and then as a broker in charge, you're responsible for what your licensee does. If you run something through the AI or you have AI create your marketing materials, and that marketing material violates license law, the excuse of, well, the robot did it is not going to fly. The real estate commission is going to hold you responsible. And then as the broker in charge, they're going to hold you responsible for the agent's conduct. One of the biggest things we see with that is in advertising. Property descriptions that The AI writes that create false information. It says, hey, for this plot of land, it can support 3 septic tanks when there's only 1 septic permit. Um, it puts in fair housing verbiage. It says, hey, this is a great place to raise a family. We've seen that kind of stuff. Um, the pictures, you take you use have AI, declutter a room and or pretty up a front yard or fix cracks in the sidewalk, all that type stuff. That is not allowed, not appropriate. The
Austin,
other,
the one that's got me for years is the photo editing or AI, however you want to call it, that puts a fire in a fireplace.
yeah,
Because it's always gotten me that what if that fireplace doesn't work? How do you are now saying that fireplace works?
hmm that's a good one. We saw one at a rel this past month where an agent had a room and said, "Hey, I want to be able to show people what this room would look like, how to make the space their own." So they were able to take a picture of a room that was full of furniture, put in AI and say, "Hey, give me what this space looks like with nothing in it." Which it did. It removed all the furniture. What it also did is it added like 5 or 6 outlets into the room that didn't exist, and it removed a thermostat from the wall. So not only now, previously you could say, hey, that's what the room looks like. There's just no furniture. Well, now it's actually, you didn't ask it to put in outlets, but it did it anyway. You didn't ask it to remove a thermostat. So I just would be very mindful of not using AI for your photos. Previously you had to have advanced knowledge of Photoshop to be able to do all that stuff. Now it's as simple as put a photo to AI. So the commission is going to hold you responsible. And again, talking about easy complaints to prove, I take a picture, as Ryan said, hey, here's a picture when I advertised of the fireplace with fire in it. I tried to start when we had the company come out and says, yeah, this fireplace hasn't worked in 5 years, and this fireplace is never going to work. It's a gas fireplace, and there's not even a gas hookup. Or, hey, we got this room based on the pictures. There were outlets everywhere. We thought this was going to be an entertainment room. We got in there, and there were like 2 outlets in the entire room. Really easy complaints to prove.
Or the ones I also think the ones that take out power lines.
Yep. Take out power lines, smooth out the concrete on the sidewalk, make the grass a little greener.
Or
Um,
put grass in where it's a
yeah,
bare yard.
yeah. So, again, how easy is that complaint to prove? Here's the pictures that were put on the MLS. Here's the pictures when I moved in. You don't even need words at that point. Um, the other issue with AI obviously is, if you put in your client's information, that's not appropriate. You put into the AI a contract and say, hey, explain this contract to me. Well, great. You now just gave the AI all sorts of information about the buyer that our buyer or seller that is uh, private information that shouldn't be conveyed. You enter in your file. So understanding that, AI is not for, you should be treating confidential information, private information as such, and not putting it in the AI.
All right. And then the last thing I think you wanted to get into was showing agents.
Yeah, so we're getting a
And
number
then
of calls.
we're going to circle back on some questions that have come in that keep coming in around advertising so that we can clarify things for people.
Yeah. All right. So showing agents. When we get calls about this a bunch, either through a private company or a service that does showing agents, or simply you and another agent are good friends, but you work at different brokerages. The only people who can show property to your client or do a open house on behalf of your client are the people within your brokerage firm. Hiring somebody or asking somebody at a different brokerage to do a listing for open house for you, a listing presentation, or take a buyer into a home is a breach of agency agreement and is a violation of license law.
Very clearly.
And if you then pay that person, you have now paid and you receive payment for it. Well, now you've received payment for real estate activity from somebody other than your broker. So now not only have you interfered with an agency relationship, but you've also now been paid. So that's kind of a double. Plus, from a broker and charge standpoint, if you go, well, what's the harm? You have you have agents who are best friends, but they work for different brokers. Ryan's in a pinch and says, "Hey, Austin, can you go do my open house for me?" I say, "Sure." Someone comes to the open house, falls down the stairs, breaks their leg. The person who breaks their leg is now going to sue the homeowner for probably being unsafe. They're going to sue Ryan and his brokerage because his name's on the sign. They're also going to sue me and my brokerage because I was there. So now I've got a lawsuit for a property that I wasn't even involved in. So don't do it.
All right. So let's get back to where there seems to be a lot of questions around advertising. First is, and that question was asked about advertising new construction homes. I would actually go broader because, as you said, it's the same. For people that have maybe broken this advertising law for new construction homes or resale homes, should they go delete those things off their social media now?
Probably wouldn't hurt.
Okay. All right. All right.
And definitely correct the contact going forward.
Okay. Because like if they didn't have the broker's permission, the home builder's permission, should they should they basically.
Correct. Yeah, I would not continue the violation.
And continue it means continue to have it out there.
Correct.
All right. And then because all it takes is one ticked off client or other agent to go find it all and report you.
Correct. And it may not even be somebody involved in that particular transaction. You may aggravate somebody in a completely unrelated transaction, and they figure, hey, what's the best way to get back at that person? I'm going to spend the next 2 hours scouring their social media for any possible hiccup they've made in the last 2 years.
All right. And let's get back to the IDX thing. So if I am posting a link on my social media that goes back to the IDX website, my IDX website that is MLS compliant and discloses the brokerage, because the Code of Ethics has the one click away rule. MLS, you post a link on social media. Is that allowed without specific brokerage advertising rules to say, this property's there?
So we look at number 4 here. This is distinguished from the IDX fee in your brokerage website. They go look at the footnote. IDX rules for an MLS typically contain provisions that require the listing agent to obtain the seller's written permission prior to entering the listing. To understand, it will be displayed and managed according to IDX rules. Also required the listing broker's name be displayed prominently and located on each of the listing for the search results screen. It is important the licensees to review the terms of service. So to me, that seems if you're doing that you're good. It's when you don't
Yeah, let's go
part with
down to the example.
yeah. I think that's for something
Oh,
different.
that's for something else.
That's
Okay,
something
never
for
mind.
something different. Yes, that'd been too helpful if we example. But the fact that to me, the fact that they have carved out IDX feed on your website, and then it talks about the fact that for someone to be on the IDX feed, it has that. I think as long as you're linking from the IDX and now personally, if there is the ability for me to add in a brokerage name, I'm going to do it just to have the extra, hey, I'm going to share this link. I'm also going to go, hey, check out Brokerages A's listing. Just as super cover for me.
All right. So the coverage is as long as you're posting back to the IDX link that has all the disclaimers you need, but be very covered by putting the broker's name in the post itself.
Yeah. If you do that, then you're 100%.
All right, cool. And then, I think a lot of questions come up, and this is more of a thing, but about buyers wanting the photos of their homes and all that taken off of your post afterwards after you sold the house. For those that don't know, Flex MLS for CHMLS has a setting that allows you to make the photos private only in the system and no longer syndicates that out. That's how you would use that within CHSMLS for that photo feature setting. But any advice for dealing with photos and privacies after the home is sold?
Yeah, unfortunately, once the photo's on the internet, it's there for forever because you may think it's on 5 websites and there's another 50 you're not even aware of. Which is why in our listing agreement we have that the seller grants a perpetual irrevocable right to take photos. And that's not because they're going to keep using you and advertising. It's because hey, once it's out on the internet, it's there for forever.
Yeah, and
So
I know that always after the sale, the buyers always sometimes buyers be like, "Well, I want those photos taken down. They're of my house." We're like, "Yeah, but they're not your photos."
correct. They weren't taken during. I would do what you can to accommodate, but understand that you're not going to be able to scour that. You're not going to scour the internet. So yeah, this is where in
You don't want to delete my MLS because you want the comps there. You can use the private photo feature
yeah. So this
that
is where
allows other people inside the MLS system to still see the photos.
in 27, the owner revocably conveys all the owner's audio, photography, videography rights in perpetuity involving the owner's family, and owner's property broker. So, and that's in there too. That's essentially because photos live forever on the internet clause.
Okay, and that'd be social posts and everything else, because that's
Yep.
all of them all the time.
Yep.
But really, how you want to handle it with your clients is something you should be deciding after that. Legally, you can, but then the question is, how do you want to handle it with your own clients, though?
1,000%.
All right, Austin, thank you very much. Just a reminder, if you can show everyone where to get to all these memos from the
Yeah.
LLR.
Yeah. So, real estate commission website, lr.sc.gov. I would first look on the alerts because these are the most uh, current ones. But if there's additional ones that we cover today, commission information, publication and news, and then for that inspection form, approved resources, inspection information.
All right, and Austin, how can everyone reach the Sakana Realtors legal hotline, which is one of the main benefits of being a realtor you have access to? How can they reach you guys, and what should they be calling you guys for?
Yeah, so 803 807 or sorry, 803-772-5206, 803-772-5206. It gives a call anytime you have any license law questions, contracts questions, at the code of ethics questions. Um, Really, anything related to real estate, we're happy to answer if we can or point you in the right direction if we can.
All right, thank you very much, Austin, for taking the time
Thank
today.
you
We
all.
really appreciate it.
Yeah, thank you for the invitation.